Thank you for having me here today. A little bit about myself. I'll go over kind of the landmines associated with the manufacturing industry. We'll get a little bit more into that. Fargo Patent and Business Law, we're a patent, IP, and business law firm. So our focus is really in the IP space, patents, trademarks, copyrights, trade secrets, and then the business law side. And that's really in the space of corporate law, bringing on investors, contracts, entities, that sort of thing. I'll get into a little more detail with that. A little bit about myself. So over the years, I've been involved in a number of different projects. I have an engineering background, went on to law school. I've been involved in a couple different manufacturing deals, startups, got involved in cryptocurrency, investment side. So I kind of got to see both the business side and then the legal side as well. So I've got a good exposure to both. Some of the companies I've um, owned or on the left side or been part of. What I do today, so I did those, sold a lot of that off in previous years, but I transitioned into the practice of law. And I worked with numerous startups, numerous established manufacturers, numerous businesses, and I had hired attorneys over the years. I had worked with them, and it fit very well with transitioning into the practice of law. Because what I do really in this day and age, in the practice of law, I work with innovative businesses. I team with innovative businesses in their growth by counseling strong legal foundations. And as someone with an engineering background, a business background, really at the end of the day, uh, we are engineering your legal documentation to really build that strong legal foundation for you to grow upon. And we do it a couple different ways. We team with our innovative businesses by, you know, being part of the team, being their fractional in-house counsel. We team with the innovative businesses by just doing pay-as-you-go type plans. So a lot of what I'm going to talk about today are things that I deal with and I come across, fairly often. I'm going to definitely hit on the IP side of things, IP being really the space we spend probably the majority of the firm's time in IP. So I'm definitely going to hit on the IP side of things. I'm going to talk about IP infringement. What about failing to protect your IP? That's a risk in itself. I'm going to mention contractual relationships and the risks, some of the risks that go with those, MAP policies, and having a consistent pricing policy in your marketplace, product liability, regulatory compliance, corporate compliance, and how that works into your business and potential future sales. There are certainly other landmines out there. Um, Human resources, political situations, tax and finance, import, export, false advertising. It, you know, there are so many different types of risks out there. So I'm not going to hit on all potential legal risks, just kind of the ones I noted. Um, so I'll dive in with kind of the first risk identified, and kind of what I want to point out when it comes to IP. There's really two sides to the risks. There's, am I infringing on someone else? Am I, infringing on someone else's trademark or patent or whatever it might be? And then secondly, is my competition going to rip me off? And they're two distinct things when it comes to IP rights. Just because you have an IP right doesn't mean you have the right to do it. You have a right to protect yourself, but it gets very complicated at times. So first risk, IP infringement. And what that means is, hey, I'm a manufacturer. I'm producing a product. I'm producing whatever it might be. I don't want to get a demand letter from some attorney in California saying, hey, you are infringing upon my rights. And really, there are two scenarios to think about. And the first is someone with a legitimate claim, hey, another manufacturer in California happen to file a patent, they have proprietary rights on a certain technique, a certain concept, certain whatever it might be, and they say, hey, this is mine, I want you to stop. The other situation is patent trolls or trademark trolls or copyright trolls. And, they're kind of, they have some of the same claims, but the trolls typically don't actually practice their product. They just have the rights to the exclusivity that comes with the product. Um, you know, Companies certainly get nailed by trolls periodically, and they come after you and try to, basically extort you for money. Um, I'm going to touch on what patents are, what copyrights are, what trademarks are, but typically when you're dealing with infringing on other people's rights, you're dealing with patents, trademarks, and copyrights. Um, one, copyrights, I'm not going to hit a whole lot on copyrights today, but copyrights, the main thing to be aware of when it comes to copyrights, don't go out and copy someone's image, or don't go out and take an image off Google and put it on your website, because there are copyright trolls out there who purposely put pictures out there and with the hopes that some business goes and copies that picture, puts it on the website, and then their attorney sends a letter and says, hey, you've infringed on my copyright, pay us $30,000. And you typically negotiate those prices down. But copyrights are unique in that attorneys can oftentimes get their attorney fees out of the deal, out of the litigation. So big thing with copyrights, don't go out, take an image off Google and put it on your website. So, patents, trademarks, what can you do to mitigate the landmine of potentially infringing on it? So when you jump into a product and you're a manufacturer, you say, hey, I'm going to come out, I'm going to develop a new product that I'm going to bring to market. So some of the things you might want to think about are do a little bit of due diligence on the front end. Do some searching. Is there IP rights associated with that particular concept out there? That might look like a freedom to operate search, might look like some Google searching, but do that due diligence to try to figure out if you produce something, is there a pretty good chance you're gonna, get in the bad graces of some IP right owner out there? And, it's definitely not a positive thing if you've developed your product, you put a lot of money into setting up manufacturing, only to get a letter from a legitimate IP owner saying, hey, you're infringing on my rights. So upfront due diligence can save a lot of headache and a lot of hassle down the road. So with that, trademarks, you don't necessarily have to set up your manufacturing itself to use a trademark, but oftentimes you put a lot of money into branding a product and pushing a product into the market. So if you're going to start putting money behind a mark that you're going to use as a brand, one of the things you really want to do and really want to think about is go out and get a trademark. It's cheap insurance to secure that right on a national basis, so that as you grow and as you build your brand and as you put money into marketing, you're protecting that brand. Another thing I always, often comes up, securing your own rights. Do you have your patent? Do you have your trademark? Per se, a patent doesn't give you the right to do something, but it does help at least in securing your rights. One other product to be aware of out there is IP insurance. IP insurance is kind of a relatively newer thing, at least in the Minnesota, North Dakota. I see some people do it, not a ton of adoption, but I do think it's a decent idea. But getting IP insurance can help protect you against people who accuse you of infringement and people who potentially infringe on your IP rights. So it's something I've been working with an insurance agent lately to, try to help people get into those platforms. So we just talked about IP, don't infringe on someone else's rights. That's a big landmine you can hit. IP litigation can be crazy expensive and have a huge detrimental impact on your business. But what about, hey, I'm a manufacturer, I have a great idea. I want to protect that great idea so that, my competition, as soon as I roll it out, doesn't rip it off and do the same exact thing. Now, with any piece of IP, I always tell clients, IP is really only as good as the business behind it. So if you've got a great idea and you're like, hey, I want to bring this thing to market, you have to have a business plan. You have to have a methodology. Just because you have a patent or a trademark or some form of IP, it's not going to get you all the way. So you have to have a business plan, have to have a way to get it to market. And so I put together this chat GPT image, and these are not all the factors that go into a successful product, but these are some of them. So you come out with a great idea, you want to roll it to the market, you want to grow your brand, you want to grow your market share. Some of the things that will help get you a monopoly or get you a strong market share in your particular market, IP protection, raise those barriers to entry against your competition, speed to market, getting to market quickly, and getting to market in a way that fits the actual market need. And that's absolutely key, understanding what does the market actually want, and then executing, delivering, providing that product, actually executing on what you plan to do. And I list these things. These things aren't all legal things. When people come to me and they're like, hey, I want to avoid the landmine of having my product ripped off. I want to have a strong asset to go to market with. If you can come to me and say, hey, this is what the market needs. This is what we need to do to be strong in the market. This is how we're going to get to market. That's going to help me put together an IP plan that is much more effective. So IP, and this is specific to patents, but it's also effective with many other forms of IP as well. But if you come to myself for an attorney and you're like, hey, I know what's novel about what I'm manufacturing. I know it's not obvious. I understand what the market actually wants, and I have a business plan to back it up. Then we can really start to identify what part of the concept is necessary, what are the choke points in the industry, and then we can build an IP asset to really try to protect your niche within that industry. And when you put together a plan, you really have an internal plan and an external plan. Internally, you're dealing with a lot of things. You're dealing with vendors, you're dealing with employees, you're dealing with fellow owners. Externally, you have market competitors, emerging competition, protecting your brand. The patents, the trademarks, these are definitely centered around how to protect your space from external competitors. There are also a lot of landmines when it comes to internal IP strategy. And, some of the things you have to kind of keep in mind are, if you have a trade secret, if you have a unique idea, if you're dealing with vendors, employees, what form of confidentiality do you have in place so that your process, your methodology, your product, your great idea isn't taken by a disgruntled employee, isn't taken by a vendor, and basically diminishing the value your manufacturing business has. So internally, really thinking about how are you protecting your IP, and do you have NDAs in place, non-disclosure agreements? Do you have non-competes in place? Do you have certain clauses with your vendors to ensure that they're not going to take your product and sell it to your competitors? So there's a lot of different features that go into some of the contracts you have with employees, with the vendors. Now, fellow owners, that's another huge landmine for especially the smaller side of business, even, mid-sized business, it's a major issue. That's one of the most common disputes that blow up businesses is fellow owner disputes. And when it comes to IP, who owns the concepts? So if two owners are in business, or there's a family business, or there's a business with three owners, what happens when the parties disagree for some reason? Or what happens if one of the owners passes away? What happens to the business? Who has the right to continue the business? Who has the right to some of the proprietary information within the business? If the business splits up, what happens? What happens to that? Do the fellow owners begin to compete against each other if they so choose? So that's certainly a risk that should be taken care of. And that's not just an IP risk. That's a risk that extends all the way from IP to vendors to everything else in your business. So technology strategy. Hey, you've got a great idea. You want to protect it. Again, ChatGPT image I put together. Most manufacturers should have typically, I should say, have some form of a trade secret. Hey, our process to produce this product, we're using some techniques that are unique, that set us apart, that make us more efficient, all sorts of different things. So those are the trade secret side. And then you have the patent side. Hey, this is the outside looking, the thing our competitors can see what we're doing, that we want to stop our competitors from copying. So a combination of the trade secrets, where it's secret, there's some know-how that isn't public, and then the patents, which are, it is this public knowledge, this something that really you can't keep a secret. And you use the patents to protect that, the trade secrets to protect the kind of that secret know-how, and then contracts to govern the relationships you have with the various parties involved. And that can make up a very strong IP asset. So where do you start when you do something like this? Protect that novel concept that is desired by the market. And that's a really good starting point. Patent, it's 20-year monopoly. It, basically protects others from making, using, or selling a certain concept. It can be a process, it can be a product, it can be, all sorts of different things. There are endless useful items that can be patented. There certainly are some limitations, there certainly are some challenges, but generally speaking, a lot of things can be patented if it's new, not obvious, and a useful idea. And you can do it really two different ways, 20 years or 15 years, depending if it's a design or a utility patent. And so patents versus trade secrets. So what is a patent? A patent's a legal monopoly. It gives you a monopoly on a concept in return for public disclosure. Now I'm going to touch on what is a trade secret. And a trade secret is kind of the opposite of that. It's keeping something secret. If it does get out, then the public has it. Patents protect your good ideas, helps you avoid that landmine of having your competition rip you off. Trade secrets, keep it a secret. So licensing, or jumping into common patent strategies. So what is the purpose of having IP, and how does that help protect your manufacturing business? And typically in my practice, what we do, we work with people. Hey, maybe you want to license your IP out to another party and do that with a contract. Maybe you want to manufacture it, use it, sell it, create barriers to entry so that your competitors can't rip you off. Maybe you want to just block your competitor development. Or you're like, hey, I want to go raise capital and I want to really try to push my enterprise value so that I can get a premium valuation when I go to my investors, or I want to set myself up for a sale in the future. Enforcement, as many of you probably know, IP litigation extremely expensive. I typically, at least in the small manufacturing space or small business space, I typically say enforcement's really not a strategy you want to grab onto. If you can use IP for some of these other purposes, that's going to be much more typically a much better ROI versus going out and suing someone. Trade secret. So trade secret, there are many ways you can make a mistake when you have a trade secret. So what a trade secret is something that is secret, so it has to be secret, has to have commercial value, and you have to take reasonable efforts to maintain that secrecy. So you have your facility, you have your employees. Your employees probably are exposed to the trade secret in some capacity. You have various people, various vendors, various parties. Examples of trade secrets, things like WD-40, Coca-Cola, all sorts of different variations. It can be product formulations, it can be product assembly methods, it can be um, you know, all sorts of different things that many manufacturers deal with all the time. So one of the requirements to a trade secret, and if you want to maintain a trade secret, you have to put reasonable precautions in place, reasonable efforts to maintain that secrecy. So with your employees, with your vendors, if you have a trade secret and you say, hey, I've got this unique assembly method, I have this unique program, this unique thing I'm doing, and it can be maintained as a secret that the public is not exposed to, you really need to have contracts in place. You really need to have policies in place that maintain it as a secret. So let's say you have a great secret in your business, a great assembly method, but you've not really taken any precautions. You've not really done anything to protect it. And you have an employee leave or a vendor in your business, and the vendor sees the methodology and goes and shares it with your competition. The likelihood is competition can use it, and you didn't actually maintain your concept as a trade secret, and therefore you lose your right to protect it as a trade secret because now it's out in the general public. Now, the other piece, this is a very common landmine people step on. Someone starts a product, starts selling a product, starts a business, does a rebrand, pushes out a new thing to the market, and it starts putting money behind it, starts building websites, starts promoting it to customers. They don't do the due diligence of figuring out, is that name protectable? And is that name going to infringe on someone else's rights? So if you're going to start putting marketing dollars behind a name, whether it's your company name or a product name, a logo in your company, whatever it might be, a trade dress, a color, if you're going to start putting money into some mark that's going to represent your source of the product, where that product comes from, really it's cheap insurance to try to protect it. And going out and getting a federal trademark on a particular brand typically is not all that expensive. If you go out and you try to trademark something that is similar to some other mega brand out there, yeah, it's going to be difficult. But if you come up with a new name and it's associated with the product and you want to put money into that, it's relatively inexpensive to get that protection, and it helps protect your brand integrity. So what's the purpose of protecting the brand? Why does it even matter? And aside from the cost, of course, you put money into marketing dollars and you want to protect those marketing dollars, but what can you actually do with that trademark to protect yourself from incurring future costs. So, hey, you're in Minnesota. You want to grow from Minnesota to Wisconsin and, Texas, Florida, and all over the place. You want to expand into new markets. Let's say you have a brand in Minnesota and you don't trademark it. Someone in Florida could very well be using the same exact name, and you would not be able to expand into that market without potentially infringing upon their use of the mark. In trademark world, trademarks are really under a concept first to use. So the first person to use a name in commerce gets right to that name within the geography. A federal trademark preempts that and says, okay, you have rights on a national basis. So you're in Minnesota, you roll out a product, say, hey, in 2 years, I'm going to expand into all these other markets. Federal trademark, even though you're not in those markets yet, says you're using it in Minnesota, therefore we're going to impute your right to all 50 states. So it really protects your space in the market and allows you to expand. And I kind of call that the sword. It protects the expansion. Alternatively, let's say you produce a product in Minnesota and you're like, hey, I plan to sell in Minnesota and really don't plan to sell outside of Minnesota. Minnesota is my market. You don't want someone in Texas to come out and start using that same name and come after you in 3 to 5 years and be like, hey, we've got a federal trademark on this. What are you doing? This is our mark. And having a trademark in place kind of preemptively says, hey, this is my mark. This is my date when I started using it. I have rights to it. And someone in Texas or Georgia or wherever can't start using the name suddenly, trademark it, and then try to start a dispute with me to say, hey, no, you don't actually have rights to that name. So by trademarking your brands you're putting money into, it's going to help mitigate the risk of losing those marketing dollars because you either don't have the rights or the rights are disputed. So I spent a lot of time on IP. IP definitely something, the space I know probably the best. IP, definitely a lot of landmines in there, whether it's trademarks or patents or infringement or whatever it might be. But there are a lot of other risks as well. And, another very common risk that manufacturers deal with is contracts. So contracts really are used for a number of things. It's a communication tool, it's a legal document, and kind of from what I've seen as an attorney, contracts, the vast majority of contracts that result in a dispute are contracts that are not well defined, are either non-existent, have clauses that conflict each other, do not properly set expectations, are confusing, and so forth. So by really looking at a contract on the front side, yeah, there might be more cost, more time put into establishing the fact that, hey, this contract is put together, is accomplishing what I'm hoping it to accomplish. There very well could be more cost with that, but it very likely starts to mitigate the risk that in the event the relationship doesn't go how the parties hoped, it's going to help mitigate some of the confusion, help mitigate some of that risk that goes with people disagreeing over contracts. And sometimes contracts can be very big numbers very quickly. So a little bit of due diligence up front can really start to figure out, what are the duties between the parties? What kind of relationship is in place? Is it work for hire? Is it an independent contractor? What kind of relationship is in place? Who owns the rights? So you work together with a manufacturer to build something, you work together with a vendor to build something. Who owns the product that comes out of it? Who owns the byproduct? Who actually owns it? Confidentiality, tech transfer, employment agreements, um, relationships. There are a bazillion different ways people work together, and contracts can help define that. And I want to reiterate one thing. When it comes to contracts, I look at contracts in two different ways. Contracts are one, it's a communication tool. So there might be a lot of legalese in it and clauses and this and that, but at the end of the day, it's a communication tool. And one of the purposes of that communication tool is to clearly convey what are those terms that the parties are agreeing to. Because what you don't want to see happen is one party thinks they're agreeing to one thing and the other party thinks they're agreeing to something else. And then when it doesn't go perfectly, parties end up getting upset with each other and disputing it and fighting over it. So that it's a communication tool. That's one purpose for the contract. The other purpose is it's a binding legal document. And within that binding legal document, you want it to be properly executed. You want it to contain the terms you actually expect. And, if you sign a contract and you really didn't review it and you didn't really think through it and you didn't understand it, you very well might be agreeing to terms you didn't actually intend to agree to. So again, you have the communication aspect of the contract and the binding effect. And some of the things you want to think about to really mitigate yourself when it comes to contracts, you want to think about, who's taking on the risks in the event something bad happens. Who's taking that risk? Something's being delivered to your facility. Who's on the hook for that load and route? If something happens to the development of a product, who is taking that risk? What are the timeframes involved? If you work with a vendor and say, hey, I need XYZ by this date, what happens if that doesn't happen? Is it terminated? Does a dispute or a breach occur? What happens? A payment, that's always a hot button item. Who is paid and when and how? And guarantees. Who's on the hook for the guarantees? And this can be supply chain issues. Is there guarantees out there saying this is when the product will arrive, this is how it will arrive, this is what happens if it doesn't meet those conditions? And then another aspect, it's it certainly happens, but are there personal guarantees involved? Is there an individual on the hook in addition to the company itself, or is it just the company? So similar to contracts, MAP, so minimum advertised pricing policy. And how I would kind of consider this one is you want to have your legal policies match your marketing expectations. So if you're producing a product, and this isn't applicable to all manufacturers, but if you're producing a product and you're selling it through different channels within the marketplace, you might want a MAP policy because you're not going to want to have pricing disparities all over different channels. That is confusing to the market. It can cause problems in the market. So what a minimum advertised pricing policy does for you, it's a policy, it's a unilateral policy that governs how is the pricing pushed to the public, so that when the public or your customer, whether it's B2B or B2C, when your customer sees that product, how are they paying for it? Can they get it for cheaper from one source versus the other? How do you want to control kind of those market dynamics, and how is that impacting your marketing? Now, there are certainly risks that go with having a MAP policy. You have to be careful such that you don't end up in a price fixing scheme, end up in an antitrust situation, and end up trying to fix the market in ways that you're putting certain geographies between to certain competitors and kind of playing games that impact market pricing um, outside your unilateral pricing policy. It's kind of gets convoluted a little bit, but those are some of the landmines that go with trying to fix your pricing in the market, so to avoid consumer confusion. Another risk, product liability. Um, this is definitely an insurance issue. Um, you know, so a really good starting point is what kind of product liability insurance do you have? There are many different jurisdictions that are involved. There's state law, there's federal law, there's all sorts of different levels of jurisdictions that get involved. But product liability is something you definitely want to think through. Um, Many states have strict liability when it comes to product liability, so it's something to definitely keep in mind. Hey, do you have a defective product? Um, was it defective when it left your control? And did that defect cause injury while it was being used in a reasonably foreseeable manner? So if people are getting injured from your product and it left in a defective manner, you definitely want to address that situation. What are some of the things you can do to mitigate that risk? Quality control, quality programs, having labels, having warnings, product liability insurance, complying with laws, regulations, and having a recall process in place. Now, this is a topic in itself, and we could definitely dive a lot more detail into it, but it's kind of a big landmine to at least be aware of. Regulatory compliance, another another risk set that, there's endless different scenarios. You can violate different regulatory bodies. There is federal jurisdictions and state, and if you sell internationally, there's international concerns, and there's various consumer protection, national defense, transportation. How's your facility set up? Are you complying with human resources? Are you complying with environmental laws, worker safety? And there are many, many industry-specific regulatory bodies to consider. I certainly can't touch on all of them here today, but regulatory compliance, definitely a big landmine that many manufacturers work with and they have to sort through. So risk number 7, this is kind of the final risk, and again, I'll touch on it very briefly, but you have a business, manufacturing facility, it's a business at the end of the day. And at some point, maybe there's an exit in mind. And one of the downfalls manufacturers or any other business out there can have is how do you set yourself up for that future? Maybe it's a sale, maybe it's an investment, whatever it might be. But keeping your thumb on your corporate compliance can mitigate many issues down the road. Common things that I see owners dealing with is who actually owns the business and what percent of the business is owned by all the different parties. And that kind of speaks to having a clean cap chart. If you have 52 investors in your business, that's a pretty messy cap chart, and that can be pretty hard to raise capital in. Resolution history. As you've worked in your business over the last 20 years or whatever it is, do you have a book of resolutions? Do you have a clear track record of, internal decisions that the company has made to place you in your current position? Has there been ownership changes? Have you addressed those ownership changes? What have owners contributed to the business? What sorts of things aren't owned by the business, but owned by the ownership itself? So having a clear history there, a clear record of who owns what, definitely helpful. Buy, sell. What happens if there's a death in the business? What happens if there's a dispute between different parties? Do you have a buy sell in place to deal with those situations? Self-dealing and designated authorities, those kind of tie together. And this is an extremely common one, especially on smaller businesses. But who has the authority in the business to do different things? And I look at it really three levels in the business. There's the ownership. What decisions do the ownership get to make? That might include electing a board, it might include signing off on the acquisition or sale of a business. And then there's the board. And the board comes in many different forms. It could be governors, it could be directors, it can be, many different things. But the board, who has the right to, what does the board get to decide? Board likely gets to decide who's the CEO, who are the officers of the company, what kind of major investments is the company making, and then finally officers. What do officers get to do, and what kind of decisions do they get to make? As an officer, can you go out and sign a loan for the company? And what happens is if the officer does something that they don't have authority to, and that goes for any of the levels, when does it become self-dealing? Wherein, you're an officer, you own part of the business and you own another business, and you make a contract between the first business and the second business, and then all of a sudden the rest of the ownership's mad at you and there's a dispute on your hands. So clearly designating what authorities do the different parties in your business have. If you do that, another, very common landmine we deal with when it comes to partnerships and companies and ownership structures falling apart. So I'm gonna just cap it off here and kind of reiterate. I went through 7 risks, not all risks, but these are kind of 7 common landmines for manufacturers. And I kind of look at it, deal with it now. There's some cost to it. If you have to deal with it later, it's definitely going to be quite costly. We talked about IP infringement, doing due diligence up front, failing to protect your great ideas. If you can figure out what your marketable value is and protect it, that will mitigate a lot of things. Contractual relationships. Do you have clear and precise agreements with the parties out there, especially when it comes to high dollar items? Do you have a MAP policy? And kind of how that can be summed up. Do you have a legal relationship with your distribution channels that match your marketing expectations? Product liability, have insurance, have a recall plan, regulatory compliance, know your industry, and corporate compliance and future sales. Don't ignore it. Just address it each year, keep it up to date. So with that, that kind of concludes my thoughts on landmines related to manufacturing industries. Be more than happy to hear your thoughts or hear any questions people might have.
Absolutely. So you can either send your questions through the chat or you can turn on your microphone and ask. Anybody has anything out there?
My name's Scott. I just wanted to say thanks, Tom, for the presentation. You offered some things here that I guess in my arena of things that I do in my consulting business, I kind of think about the aspect of where do I sit down and kind of get an idea of to look at the size of the risks. And I just was wondering if you might be able to add a little bit more on trying to describe your thoughts on some of those things. If you went back to that and back to that previous slide and then kind of said, these are some of the things that might weigh into the size of the risk that's associated with those things. I guess I can look at some of them and kind of get an idea together, but I guess at times it's the size of the risk compared to what you're trying to talk about there that I might get a little could use a little insight on, I guess. And you don't have to go into much detail, but just give me an idea about how to talk about the size of the risk.
Oh, that's great question. You know, as with anything, it depends. You know, it's going to be very fact specific, very industry specific. You know, for example, contractual relationships. You know, a contract with a vendor can be a $5,000 contract. It can be a $500 million contract. So it can vary tremendously in that regard. That's just one example. IP infringement. Let's say you are making a product and, you know, you're pushing it out there. You know, IP litigation, you know, oftentimes can exceed $1 million in legal fees. So, I mean, it can get very big very quickly when it comes to IP infringement.
Well, even with taking that one just for a quick perspective and saying that, let's just think about the ability to sit down and say, you know, I guess when I think of this in some way, I think somebody has a patent out there, right? And then somebody sits down and says, I'm going to tweak this little thing and say I'm not matching that patent anymore. I guess you have to throw it, you know, kind of talk on just that particular concept.
Sure. So let's, you know, when it comes to protecting your ideas, you know, it's not a one size fits all type thing. But let's say you have an idea and you have a manufacturer, you want to protect your brand. You know, patents, just like contracts, 99% of patents are never litigated. 99% of contracts are never litigated. But what patents can do for you, it can establish whose rights who, and it can create barriers to entry and create, you know, market resistance to people coming into your industry. So let's say your competitor comes out and they're like, hey, I'm going to tweak one thing. Hopefully your IP portfolio isn't solely contingent on just one patent and one claim. A strong patent portfolio or a strong IP portfolio, you're going to have trade secrets, which is secret know-how. You're going to have probably a patent family. So you're going to have, you know, patents that kind of create a moat around a different concept. So it makes it very difficult for someone to just change one component. You definitely hear the horror stories out there where, you know, someone comes out and they say, hey, I can delete one element of a patent claiming and design around a particular patent. And yeah, that happens. But it comes down to, you know, how is the patent family drafted to try to mitigate that risk? You know, the question usually isn't, can I get a patent? The question is, can I get a patent that's valuable? And can I get a patent that is going to be difficult to design around? Because yeah, you can write a patent, you can have all sorts of different elements that make it very easy to do exactly that. So having a very clear strategy and a clear understanding of what is that value is absolutely essential. Things like, you know, protecting your IP, having a MAP policy, you know, being in compliance with your corporate formalities. It's difficult to put a valuation on those things. Because it's very, you know, it's very dependent on how does the business ultimately use those things and benefit from those activities.
Anyone else have any questions or comments? All right. I think we're finishing up right on time. Well, thank you, Tom. That was really a lot to learn. Appreciate your time. Oh, yep, we're getting some thank yous. And as I said, this will be uploaded to our YouTube channel. I'll have her do it quickly. And so if you need to review or revisit anything, it'll be available there. Oh, anything? Yep, we're getting lots of thank yous on our chat. So, all right, everyone, have a good rest of your day. And hopefully we'll see you at some upcoming webinars. We'll keep them going, and maybe we'll have Tom back here
Very good.
at some
Thank you
point.
all.
All right, Ed. All right, thanks so much.
Bye.
Bye.